Good morning, everyone, and good afternoon to those who are not in Europe, especially to David, our speaker. We are going today to discuss a really interesting topic within our BHR Mentorship Program for Ukrainian scholars, which concerns the due diligence at the concept, its origins, its developments, and its correlations with other concepts that exist in BHR field. And then we have three amazing speakers for today to discuss this concept and raised questions. Our first speaker is David Birchall, who is senior lecturer at Macquarie University Law School in Australia. Our second speaker is Radu Mars, who is associate professor at Raoul Wallenberg Institute of Human Rights in Sweden. And our third speaker is Maria Vasylechko, who is lawyer at Enzym Group, biotech company in Ukraine. And Maria is also the mentee of our mentorship program for Ukrainian scholars. So we are going to have kind of the open discussion regarding raised questions, and every participants, all the audience, please feel free to raise your hand also to ask questions to the speakers or to write them in the chat. But our first question before we go to the discussion with speakers is to the audience. Regarding your awareness of the due diligence concept. So how many of you already know what due diligence means, at least maybe in some field, in BHR field or in financial field? Yeah, can you just put some reactions or raise your hand? How many of you already know? Okay, I see. So some participants already know something about due diligence, which is great, and it's nice. Then we will proceed further with that information. And our first question to our participants and to our speakers is: how do you understand? Yes, your understanding of the concept of due diligence. And Maria, could you start?
Yes, thank you. Good morning and good afternoon to all. And thank you to the organizers for the invitation to the webinar. Yeah, and for the first question, for me, first of all, it's the topic of research. I work in the framework of this mentorship program because I decided to choose such a topic because as a business lawyer, I took part in various corporate and compliance projects which dealt with due diligence issues. And as we used this notion too often, I wanted to find out more theoretical information on it, on its origin and meaning. But firstly, I didn't succeed because I couldn't find any definite data. On the other hand, I found that this notion is used in many spheres, in many branches of law, so its practical value cannot be underestimated. So now I start working on this topic to elaborate it, to define some systematic approach and some unified proposal for the definition and legal nature of due diligence as one of the main concepts of private law. And what I found for the moment, it's widely used in business law literature. And some authors define even up to 12 types of due diligence, such as, for example, corporate, financial, environmental, human rights, social, tax, and so on. It's also used in corporate law doctrine to describe fiduciary duties of company top managers in relation to company owners. And in corporate law, it's also used in mergers and acquisitions transaction, where due diligence is an integral part of procedure which helps parties to make an informed decision after weighing potential earnings and liabilities. It's also used in banking law as a part of know your client procedure and a part of financial monitoring and anti-money laundering procedure. And in international trade, it's used to evaluate business conduct of prospective counterparties. And what is important now for us as a part of sanctions screening process. And in the tax law, it's used in connection with business purpose principle and tax due diligence doctrine, which was introduced a few years ago in the tax code of Ukraine, and means that taxpayers shall be diligent when choosing a counterparty. And due to its widespread use, some authors argue that due diligence shall be treated as an emerging principle, general principle of law. For example, similar to recognized one such as pacta sunt servanda. And for me, it's related, first of all, with responsibility and responsible business conduct. And its important role is that it establishes some standard of behavior recognized at domestic and international level. So we can say it's a guarantee of compliance with adopted rules and principles and with legal order in general. So that's my general suggestions on this question. Thank you.
Thank you so much, Maria, for such an interesting initial intervention. It's really interesting how many times due diligence used in such different concepts. And David, perhaps you may continue with your understanding of due diligence concept.
Yeah, thank you so much, Tamara, and thank you, Elena, for the invite as well. Yeah, so Maria, I thought that was a really good introduction to the topic, and you emphasize the scope there, saying 12 different types. There's financial, due diligence, human rights, environmental, of course, and many others. It's definitely a very, very popular concept today, one that's expanding and being used in more and more diverse arenas. As Maria said again, yeah, I mean, it originates from business law, from company law, for example. So in the UK Companies Act and in the Australian Corporations Act, there's a duty to act with reasonable skill, care, and diligence. There's duties of due diligence throughout the Corporations Act. So company directors must act with due diligence in all their dealings. Due diligence can be a defense in corporate law as well. So if you can prove you've acted with due diligence, that can be a defense for your personal conduct if something has gone wrong. If you're a company director and you cost your company money, if you can demonstrate that you've met the due diligence standard of conduct, that can be a defense for you in court. I suppose to take it back a step as well. So firstly, I think in a sort of a fair definition of due diligence would be to take all necessary precautions to mitigate any relevant risks to your business or in any situation we might be talking about. So it's all about understanding the relevant risks and taking all necessary precautions. As Maria said, it features in finance, so it features in mergers and acquisitions, or any element of business law, and of course we'll go on to talk about the human rights component of it as well. And I guess the other thing that is important about it as a concept would be that it is a standard of conduct, which means it is a sort of an objective standard which can be externally defined and which individuals have to live up to in particular situations. So it's a standard of conduct. So it's a way you should be behaving. So to behave with reasonable diligence is to say you are taking the necessary precautions and doing the necessary research into whatever it might be. So if we're talking about human rights risks, we're talking about the company director or whoever it might be, making sure they have an accurate understanding of the human rights risks in a particular situation. In finance, we're talking more about financial risks and so on. But yeah, I think that's how I would understand the concept. So it's a standard of conduct to take all necessary precautions to mitigate the relevant risk to your own business or whatever the situation might be. I don't want to veer into other questions too much for now, so I'll just leave it there for now.
Okay. Thank you so much. And Radu, can you share your perception?
Yeah, so for me, and good morning, everybody. For me, due diligence, it's about risk management. It's about responsible management of risks, whether they are human rights risks, business risks, sustainability risks, and so on. Can be political risks as well. So it is a risk management approach that Maria and David showed that it's very popular in various fields of law, of business practice. It's pretty much everywhere. And it's used to clarify the responsibility of businesses, but let's remember also the responsibilities, the obligations of states. Then I think another aspect of due diligence is how practical it is and how operational it is. So it has these very practical connotations that are very useful for practitioners, whether companies, managers, but also other practitioners in civil society groups and governments, because otherwise human rights language can be quite technical. Remember the obligations of states: respect, protect, fulfill. There is a lot of jargon, and sometimes for newcomers it can be quite threatening. It can be quite legalistic as well. And the message just doesn't go through. So John Ruggie, when he put forward this concept back in 2011, he was very practically minded. He had this philosophy of principled pragmatism. So the pragmatist part put him on a hunt to find those concepts that can be very practical and resonate with practitioners. Which brings me perhaps to the third function, is this unifying function, I would say. Remember where the guiding principles came out of: a big debate between civil society, states, and companies that couldn't agree on the basics, the fundamentals of what are corporate responsibilities. And Ruggie's job was to fill this gap, clarify, but even more importantly, to get a bit of a consensus between groups in society. So could civil society groups, companies, and states agree on what has to be done? It can be as basic as that. And then the answer was, well, it is actually due diligence. That's the minimum. And with his American style, he labeled it the know and show approach. So know what are your impacts and show how you are dealing with them as a company. So this unifying function in terms of, increasing the level of agreement, finding a consensus, was very important for this new instrument, the guiding principles, which, remember, it's not a treaty, it's a soft law instrument. So the only power it has, it's really this backing it has from civil society groups and its authority coming from the UN. And we can talk more about that. Perhaps one more thing, it's, for me, due diligence is very much about prevention. So you don't have to wait as a company for harm to take place and to be held liable in courts of laws, but basically you need to take preventive action. So that's very important for human rights, because can you really remediate human rights violations? It's not so easy. Compensation is not the way. So prevention, I think, is very strongly associated with due diligence. As the other speaker said, in all the fields where due diligence is used, it's about proactive action, preventive action. What can we do to prevent harm from taking place in the first place? But it's not only about prevention, so we can talk more about that later on. So for me, it would be this kind of, risk management, very practical, preventive, and it has a function of bringing stakeholders together.
Thank you so much, David and Radu, for your thoughts on that. And it's really very interesting to realize that it's goes much further and beyond the BHR agenda as a business and human rights field, and touches upon different corporate and other of legal regulations. It's also interesting which was raised yes by David as behavior, yes, as responsible behavior, and by Radu that it can apply also to political processes, and it's also yes very interesting that it even can apply to governments, yes, as we perceive it as general principles of conduct. So the next question is really connected to the first one, because when we go to knowledge and to our perception of due diligence, our business and human rights, yes, professional landscape can affect a lot. And then even our speakers just now shared their thoughts about the concepts and the contents of this concept, but it's also interesting what it is, the origin of this concept, yes, from where it came from, where it was developed in financial law or in political law or in governmental law. So it's very interesting, and we will be very grateful to hear your opinions on that. Maria, would you start on the second question?
Okay, thank you. We can suggest that it's an old principle, and we can see some elements of this concept even in ancient times in Roman law, because it fixed the principle of diligentia in two forms. First, diligentia quam vis rebus, and this meant the duty of care which should be taken by a person while managing his own affairs. And second, it was diligentia exactissima, or diligentia boni patris familia. And this meant the duty of care which should be taken by the head of the family. And we should mention also the legal maxima civit emptor, or let the buyer beware, which also originated from the Roman law and later developed into a common law principle, which imposed a burden on the buyer or the seller to know information on the prospective transactions between the parties. So we can argue that it's an ancient and fundamental principle, the main aim of which is to set some standard of behavior. As for the very notion of due diligence, it has originated from the common law system in medieval England. And in the 17th century, English law distinguished 3 degrees of diligence, such as law or slight, and common or ordinary, and high or great. And later, at the legislatory level, it was firstly fixed in 1933 in the United States Securities Act, which mentioned a process of reasonable investigation, because the American laws on security used to impose huge liabilities on the dealers who sold securities or properties to the public. And this legally required standard of care was known as due diligence. And this notion is also widely used in the doctrine and practice of public international law, where it firstly appeared in relation to states' obligation to protect against the most serious human rights violations and cross-border environmental violations. It was used also by international courts to establish the existence of a state legal duty to take reasonable steps to prevent human rights violations and to use the means at its disposal to carry out serious investigation of violations committed within its jurisdiction, to identify responsible persons, and to impose the appropriate punishment and ensure the victim adequate compensation. So the important role of this notion in public international law is that it can be used as a foundation or ground to establish legal duties of large actors such as states. And as a result of it, private actors such as citizens can apply for legal protection and claim compensation for the violation of their rights, even at international level. And in 20th centuries, this notion evolved, and now it's widely used in public and in private law. And the nature and the role of due diligence in public and private law depends on the context. And there is no general notion here of due diligence in international law. And due to this, some authors argue that the application of this notion can remain but like one of someone's political will, yeah, and this could cause a problem and lead to possible speculations even. Thank you.
Thank you so much for this interesting historical contribution about how it evolved, yes, starting from the ancient times, Maria. And Radu, would you continue?
Yes, I can do that. I was in the middle of answering a question in chat, so I will resume after that. Yes, I mean, Maria really went back in time. With any powerful idea like due diligence, you can really start digging in the past, and you find that the roots of those powerful ideas go very deep, maybe 2000 years ago in law. And you have a continuity because of the usefulness of this concept. If I can start maybe with our field, with business and human rights, we all know that the UN guiding principles kind of shot this concept to the center stage of business and human rights. I would say that John Ruggie revolutionized the field of business and human rights with his UN guiding principles. And at the heart of those principles is the concept of due diligence that we discussed. If you want to see a bit more like in business and human rights, in CSR, has due diligence been used before, you can go to the previous attempt in the United Nations to standardize business and human rights. And those were the 2003 draft norms on the responsibilities of transnational companies. And that is written in a language of lawyers, so it sounds very different. And if you look really hard for due diligence, you will find it, but it's buried in one place only. So it's not center stage. So you can see the shift in thinking and language that basically John Ruggie was very innovative in the way that he conceptualized and positioned due diligence in the business and human rights field. As Maria has said, I mean, you can go in history either on the legal track or on the business track if you want. So if you are a lawyer, maybe you are interested to go to different areas of law, whether it's business law, securities in the US in the 30s, the standard of care there that Maria explained. That's a very useful reference if you are into finance and you want to understand the duties of issuers, of traders, of securities, and how the system of law protects the consumer, the buyer of those securities. So due diligence is very important together with transparency. You can also go in international law if your background is public international law, if you are interested in state of obligations. You can go to the Lotus case. There are cases of arbitration between cases about the treatment of aliens, the protection of aliens under international law. And that's primarily about the obligations of states, so states having to do due diligence. For example, to prevent their territory to be used in harmful ways for other states. Environmental law, international environmental law, it's also an interesting precedent. So perhaps I'm talking less about the origins and more about precedents, if that's a distinction. So these precedents to me are very insightful because you have a lot in environmental law like transboundary harm. So you have all kinds of principles and instruments regarding environmental harm that originates from other states. And if you are into human rights law, international human rights law, with an interest in obligations of states to respect, protect, fulfill human rights, you will also find obligations of due diligence of states, primarily as obligations to protect human rights. meaning to prevent and hold third parties accountable if they infringe the rights of other private parties. So the state is the monitor, the supervisor, what happens between private parties. And then the state is understood to have an obligation of due diligence, whether it's issues of domestic violence or any other type of problems between parties. So indeed, and there are many others. The question in the chat is very good because it goes into know your customer. It can be corruption issues, many other issues. So it's a very versatile concept. Let's remember that due diligence, it's a very useful concept, and it came kind of late to business and human rights because it's been used before. So, and if you want to go more on the business side, and I would maybe want to give you a few sources of further readings or documents you'll find very important and insightful would be perhaps a totally different system is the World Bank, the International Financial Corporation. So basically development aid given to states if it's the World Bank system or directly to businesses if it's the International Financial Corporation. And the IFC system has been around since the 90s with conditionalities, with sustainability requirements for businesses that would receive the grants or would take the loan from the IFC. And these conditionalities now they are known as the performance standards. The latest version, I think, is from 2012. Has very detailed due diligence provisions, but they've been around from before the guiding principles, and they didn't use due diligence at all until 2011 with the guiding principles. So it was all about management system, about processes, about very much more detailed than the guiding principles. But the whole idea that this has to be risk management to deal with sustainability risks, it's all about that in these performance standards. So if you want a more detailed, more business a language, and kind of a different language altogether, then you can look in these IFC standards. And of course, they were revised in 2012 after the guiding principles, and now they include references, but not too many to human rights due diligence as in the guiding principles. So that I think would be a good source for inspiration. If you want to go down the legal route and basically see how this concept has been used in different legal fields, the International Law Commission is looking right now in due diligence under international law. They have a report from last year, about 15-20 pages, where they really screen due diligence in law, and they come with pretty disturbing assessments, meaning the concept is poorly defined, the scope, the contents, the nature of the concept, the legal character is not very clear for lawyers, part of this commission. But that's only about due diligence of states. So they kind of made up their mind not to look into due diligence of companies. So you will only get the state obligations of due diligence there. So track down this thing on the very important issues that was highlighted before, standard of conduct or a process of responsible risk management. The debate between John Ruggie and Bonnicia and McCorkerdale is a very famous scholarly exchange from 2017 in the European Journal of International Law. So if you track that exchange, you will really learn a lot about some of the nuances of due diligence in business and human rights. And then, of course, the OECD has numerous guidance, general guidance on due diligence, but also sectoral guidance on due diligence for high-risk industries, about 5-6, I think, and it's very detailed there. So this, I would say, are good sources if you really want to understand the origin, the precedents, the applicability of due diligence.
Thank you. Thank you so much, Radu, for such a deep intervention regarding the development of this principle and concept within business and human rights field. And David, would you like to share your thoughts?
Yeah, thank you so much. Yeah, I think both Radu and Maria gave so much detail there. I'm not sure what I can add really to the origin of the term. But just one thing to say that hasn't been fully explored maybe is the link between due diligence and duty of care, which in common law jurisdictions at least is the other key way that corporations are being regulated today, and the other sort of key concept that is expanding to cover the business human rights field and perhaps even more so the environmental field. So duty of care means that every individual, and that can include corporations and states in different contexts, have a duty to be reasonably careful, to take all reasonable precautions in their, well, it comes from tort law, which is like personal injury law. So that's talking about an individual has a duty to be reasonably careful when they're going about their life. So when they're driving a car, or when they're when they're building a house or whatever it might be, they have a duty of care to be reasonably careful, reasonably safe, and so on. So that now is being expanded or has been expanded in various ways. It's often used in environmental cases, the idea that the state has a duty of care to mitigate climate change following the Paris Agreement, and other environmental rights are often addressed in this way as well, and environmental harms. The same for corporations and the environment. And then most famously in a business human rights sense, you've got parent company duty of care. The Vedanta case is a key one there, as well as Okpabi, two cases where parent companies were held liable for harms caused by their subsidiary. So I'm not sure how much knowledge people on the call have, but a parent company, but broadly speaking, a parent company is one that owns a subsidiary. So a parent company is the owner, subsidiary is the property that it owns. And there are big problems in company law due to a concept called legal personhood, which means that each corporation is its own distinct entity, has no responsibility for any other corporation. So this means that a large corporation can start a new subsidiary, and that can cause harm, and then they can close that subsidiary down without paying compensation. And this is all perfectly legal. And this has happened quite a few times. This is a risk that's caused a lot of harm around the world. Particularly, we're talking here multinational corporations that are headquartered, for example, in the UK, and then they have subsidiaries operating in places in the world where potential victims cannot necessarily easily access the court system. So Okpabi was in Nigeria, for example. So you have a subsidiary operating in that case in Nigeria, causing harm, and the victims have no easy way of no way at all of getting access to remedies. So the solution to this that was proposed was parent company duty of care. So to say that the parent company owes a duty to be a duty of care, so a duty to be reasonably responsible for the actions or to take reasonable oversight, let's say, of the subsidiary. Many different nuances to it, not a perfect standard at all, but we're talking about due diligence, and so just highlighting that alongside due diligence, which in the business human rights sense, as Radu has said, emerges from the UN guiding principles as a voluntary standard that corporations are meant to perform, now becoming mandatory through the CSDDD and other mandatory human rights due diligence laws. But at the same time, there's this other legal avenue, which in some ways looks quite similar, because both of them are saying that the company should be taking reasonable care to ensure there are no human rights violations going on, or in the duty of care sense, technically we're talking tortious harm, but actually used for what would also be termed human rights or environmental rights violation. So this, I suppose, sort of the analytical or the theoretical sort of interesting part here, I suppose, and I'll just leave this as an open question for now, but why exactly this notion of being careful is so important today, why we've chosen this sort of personal this is kind of personal, interrelational type of care. So we have to take care of our neighbor, this kind of thing. We have to be careful for these people we're interacting with. So these concepts have always been about company directors and individuals taking reasonable care in what they do, now being expanded to new areas and being used in new fields. So interesting that that's the approach we've taken, perhaps, to so many different types of problems, like moving from finance to human rights to environment. These kind of interrelational, duties to be careful has become the norms that we've chosen. Just a tiny bit there on the link between due diligence and duty of care. Yeah.
Thank you so much, David. And indeed, there are different intersecting concepts that exist in law, and which are really important to understand, that sometimes they can be used simultaneously in a legal language, and it's really interesting how duty of care correlates with due diligence. We also have a nice discussion in the chat, actually. Yes, while our speakers were presenting, just to briefly mention that one of our participants asked how customer verification is part of know your customer procedure carried by compliance unit. Yes, and know your customer procedure is only part of due diligence process, and Radu kindly responded already. So Radu mentioned that know your customers is due diligence is did, and it's more of a commercial transactional due diligence, deals with identifying risks to business. Human rights due diligence is partly similar, but has other elements that are unique. And most of human rights due diligence is about risk to title holder to human rights, not to business profitability. And we had another question from Snezhana, and she asked, could you please clarify how does the due diligence concept fit into the situation of crisis? Which means that some risk transformed into reality, thus we don't work with the risk prevention in a way. So maybe perhaps someone can elaborate on that, how this concept and how your perception is about due diligence in times of crisis. Does it differ from other situations, or is it similar and has similar principles? Does any of the speaker want to?
I could give it a try if nobody else jumps in.
Okay. Yeah, I'm just reading a question now, so please, Radu, you go.
Yeah, okay, I'll try to be short, and please chip in, David. Yeah, I mean, it's a pretty fundamental transformation. So when you talk about prevention, the harm didn't happen yet. Okay, it's still a risk. It might happen, it might not happen. In the moment when the risk has been transformed in a harm, so the harm has happened, or the situation of crisis, if I understand it correctly, then who's liable for that harm happening? Who's providing the compensation, the remediation? How do you make the injured party whole? So you have to repair the damage. So that all has to do with the damage having to be remediated. And here the guiding principles in principles 13 and 19 and 22 clarify this concept of remediation. So it's all about the issue of involvement of the company with the party who directly causes the harm. So this is the famous causation, contribution, linkages, the three types of involvement of a company with the human rights abuse. Typically, we talk about human rights abuses, situation of crisis or damage if it's private law. And this causation, contribution, linkages clarify that the parent company, when the suppliers are infringing human rights, might have to compensate or might not have to compensate depending on some factors, primarily how closely involved it is with the harm. Did it jointly cause the harm or not? So if you didn't have any role in this causation, then you as a company don't have to compensate, you don't have to remediate. You can help if you want, but it's not your job. And whose job it is, of course, somebody has to remediate it. The job of the state under international human rights law obligation, and the job of the supplier, the company that directly caused that harm. So this is what happens when a harm has happened, who is responsible, and of course some issues are still up for discussion, but this is the framework of the guiding principles.
Thank you so much, Radu. Olena, do you want to?
Yeah, thank you very much for this discussion, and thank you for this question to Snezhana. Now, first of all, of course, we would need to clarify what do you mean with crisis, because so if we are talking about crisis when, for example, the state's ability to protect human rights is very limited because of armed conflict or because of COVID-19 or because whatever, I think, as Radu said, it's a fundamental shift, and I think that we need to take into consideration several factors. First of all, as I mentioned, for me, one of the key factor is this limitation of states' ability to protect human rights, and international human rights law even allows to states to derogate from their obligations according to international human rights law, not from all of them, but from many of them, because the international human rights law also goes with this regime, with this understanding about the limitation of ability to protect human rights in some situations. But does it mean that businesses also, can, let's call this, to derogate from their human rights responsibility? I don't think so. No, in any case, we need again to apply this principle of standards of behavior. So they should make all possible reasonable efforts to proactively identify risks. And if in normal, usual situation, we are talking about risks which company creates, or again, as Radu already said, company creates or link it or contributes to. In situation of crisis, I think companies also need to take into consideration additional risks or additional possibility of risks which crisis creates. COVID-19 creates, so companies are not responsible for COVID-19, but they are responsible for stakeholders, and companies should make these reasonable efforts to identify what kind of additional impact on human rights this crisis creates for their stakeholders, and make all possible efforts to prevent, to minimize this risk. Of course, if we talk about armed conflict, companies also should take into consideration the possible impact on the conflict and possible impact of the conflict on human rights. So basically, I think that it's what we call heightened human rights due diligence, but again, it's a separate discussion, and it's very interesting also, and it's also separate discussion about human rights due diligence and corporate responsibility to respect human rights in non-democratic regimes, something like, or in situation of political crisis, and again, for example, if the state just decides to not to follow some international human rights standards, what should companies do? Basically, what we see now in the US and the impact of the, I would say, political crisis in the US and its impact on companies' behavior.
Thank you so much, Elena, for this thoughtful intervention and discussion. Indeed, it's really important to understand the scope of the due diligence process and how it applies to different concepts, and not always states are ideal. Yes, so we are not only talking about businesses obligations, but also the contexts where they operate, as great mentioned by Snezhana, and crises can vary, of course, from one to one. Returning to our questions, and also it's also really connected to what we discussed further, because the next question was, and it really greatly touches upon the Radu interventions about the creation of due diligence in UN Nation Guiding Principles of Human Rights by John Ruggie in 2011, yes, when he contributed and created this concept for specifically business and human rights field. And then it was back in 2011, and now we are in 2025, and a lot has happened since then, and both theoretically and in legally field. So it's really interesting how you see this development of due diligence concept as business and human rights concept within current theoretical and legal developments regarding business and human rights field. Maria, would you like to start?
Thank you. As Radu mentioned, this principle is in the heart of UN principles and OECD guidelines for enterprises. And we can say that now it evolved to be widely used in soft law and in legal acts which regulate sustainable business. For example, in UN principles, guiding principles on business and human rights, they foresee that business enterprises should carry out human rights due diligence. And initially, due diligence policies were largely focused on addressing negative impacts on human rights. But later, this concept evolved into a broader notion to include also social and environmental concerns. And now it's used in the European Union directives on sustainable business, such as corporate sustainability reporting directive and corporate sustainability due diligence directive. For example, under CSRD, due diligence is the process that undertakings carry out to identify, monitor, prevent, mitigate, and to bring an end to the principal, actual, and potential adverse impacts which are connected with their activities, and to identify. And this directive identifies how undertakings shall address those adverse impacts. And this notion is also used in CSDDD. This directive doesn't define this notion yet, but we can say that it incorporates it because it imposes obligations to conduct sustainability due diligence. So we can assume that in recent years, due diligence has become one of cornerstones of corporate sustainability policy at the European Union level. And as some authors suggest, that after the CSDDD adoption, let me cite the dream of a harmonized horizontal sustainability due diligence framework in the European Union is steadily approaching a reality. And to my mind, the main importance of these legal instruments is that we shall set some standards of commonly recognized and admissible business behavior, because as David raised this important question about responsibility of multinational companies and parent companies. one of the aims of these directives is to foresee some standards of behavior, yes, some reporting standards of parental companies, and we hope that these new directives will address and somehow try to solve all this issue here of responsibility at international level.
Thank you so much.
Thank you.
Yes, it developed, and we see a lot of initiative in environmental, in social, pillars, because we have 3 pillars of sustainability: environmental, economic, and social, which are developing now really intensively in different legal documents, soft law and binding ones, and it's really interesting to hear opinions of David and Radu. David, could you share?
Yeah, thank you. Yeah. So the question being, so how has human rights kind of changed or evolved as it's become part of business in human rights? And I just want to focus on one thing really, which is the concept of risk management under due diligence. So, because I think this is something that's very, very different when you move it from the finance sector to human rights. So financial due diligence, so say if a company is buying another company or thinking about buying another company, financial due diligence means you check into their financial statements, their liabilities, cash flow, all that kind of stuff. You get all that information, and then you make an informed decision on whether to buy the company, right? It's not controversial. There's no question of incentives not being aligned. There's no kind of, it's maybe a complicated process to actually perform, but it's quite straightforward in how it works. And human rights due diligence to mitigate and prevent human rights risks is not anywhere near that simple. You're still trying to investigate the human rights risks of your particular operation, but there is now a big question of incentives coming in there, and there are lots of different kinds of definitional problems and problems of scope that financial due diligence does not have in them. So for example, human rights risks can be conceived more broadly or more narrowly. You can include a wider range of human rights or a more narrow range. So the UN guiding principles includes all human rights or all internationally recognized human rights. The CSDDD is a lot more selective as to their human rights. And other documents include just modern slavery, for example. So there's all these different types just in terms of legal documents. And then any company doing voluntary human rights due diligence under the UN guiding principles, well, they're free to choose whatever focal point they want. So that means that businesses are making choices not so much based on the human rights risk, but based on the risk to the company, right? And particularly in this context, socio-economic rights, which are material rights, so things like the right to housing, right to health, including healthcare, right to education, things that cost money, essentially, they are often going to be ignored because they can be very, very expensive for businesses to have to deal with, and they are, to some extent, perhaps perceived as less important than certain things like child labor, for example. So companies have to make, or well, they don't have to, but they can make those choices. And the reason I bring this up is just because this is, I think, a very fundamental difference between human rights due diligence and finance due diligence, right? In finance due diligence, you're trying to work out, is this a good company for us to, in this particular context anyway, is this a good company for us to buy? In human rights due diligence, you are trying to mitigate and prevent the human rights risk, but at the same time, it's only logical that a company is going to try to define those human rights risks in a way that makes them relatively easy to mitigate. And as we've seen with the long process of the CSDDD, which is nowhere near complete, there's so many debates about scope, which are very, very important for human rights due diligence and just don't come into the question for financial due diligence, particularly anyway. There's a question about whether companies performing human rights due diligence really want to know these human rights risks. So Ruggie uses the term know and show. Companies should know and show. they're performing adequate human rights due diligence, that they know their human rights risks. But there is an obvious possible incentive to not learn this information, because if you don't learn it, then perhaps you have some reason to excuse yourself from doing anything about it. Again, in finance due diligence, this does not come up because you don't want to buy a company that you then realize actually is going to cost you lots of money. So there are some key differences. Exactly, what that means for the concept of human rights due diligence, and I'm not sure. But just to sort of highlight that bringing the concept of due diligence from finance to human rights does entail a lot of extra questions about it, for sure. Yeah.
Thank you so much, David. Radu, would you like to?
Yeah, so we are on the third question here and about the changes in the business and human rights field. So I sense the danger here that I will speak until tomorrow. So I will do my best not to do that. But first point, changes everywhere, whether in business or in human rights. If we just look at the context, business deglobalization, whatever happens today, Trump put tariffs on China, whatever, 100+%. 20 years ago, if you came with this idea, people would have laughed at you. So it's really, the economic system is changing dramatically. WTO is, I don't know, dying, folding up, or in a sleepy period, I don't know, but the whole trade system is changing. Human rights movement in itself, it's doing soul searching. There are lots of attacks, controversies, reflection whether the movement is succeeding. So there are lots of threats to human rights as well. 20 years ago, human rights perhaps was on a wave, at least in theory, in concept, it was a widely accepted and popular idea. Now it's much more skepticism in different corners. But then more to the question of business and human rights or due diligence in itself. In Europe, the legislative changes under the EU Green Deal have been the most obvious change. So this shift from soft law to hard law that we have seen in Europe only, outside is not so much. So remember, it's a very limited phenomenon. This has huge consequences in terms of the level of detail, the specification of what it means to do due diligence. This level of detail was not there, not in the guiding principles, not even in the OECD guidelines. And the level of thought and hard choices from a lawmaking perspective are quite obvious when you look at the due diligence directive and the civil society campaigns and the different models of due diligence that you might end up with. So that's a huge change, I would say, from soft law to hard law. That creates new incentives, new detail, and changes a lot. Outside Europe, I would say that standardization is probably the big game. ESG, environmental, social governance standards. Again, lots of change there, backlash in the United States. It's part of the culture wars, but outside of the US, ESG is a very popular idea, very much about the risks that sustainability brings to the companies, though. So we talk about financial materiality here, not so much about impact materiality. But I would say ESG standardization as a market instrument is very powerful, and we have to see now, because there are measures taken to deal with greenwashing, whitewashing, these misleading claims that finance is making, and there is a reaction to that both in EU and in other places through standards. So I would say standards as opposed to obligations are a very, very significant change, which leads again to a lot of specification. Then another change, I would say, we talk about human rights due diligence, but what about environmental due diligence? The EU is treating them together. Sustainability due diligence comprising both. This was not in the guiding principles. The guiding principles spoke little and indirectly about environmental due diligence. There are commonalities, but also significant differences. So I think this expansion of human rights due diligence in sustainability due diligence. It's extremely important, and it happened primarily, I would say, through the OECD, because they really took the guiding principles idea and really applied it to the whole sustainability field. And now the EU is doing the same with plenty of laws. And I think this is kind of fundamental in many ways, but maybe I can revert to that. Theoretically, I would say it's basically this idea that due diligence is the norm. Companies should respect human rights, but then you need this regulatory mix of measures, that so-called smart mix of measures, meaning that it's not only the market, but the states have a role to play. So you end up with market and legal incentives that are combined in a very smart way, or at least they are combined. So this combination of private and public actors in order to mainstream due diligence and make it impactful, I would say that's a theoretical development in business and human rights in the last 10 years or so. Of course, that comes from regulatory theory from the 1990s. So there is a lot of scholarship that existed outside human rights, and it was primarily in the environmental area. So now this is moving. So I think it's really important to see this interplay between the environmental and the human rights side of due diligence, both theoretically but also practically with this sustainability due diligence laws and standards. Yeah. Continuing on this smart mix idea, which is something that John Ruggie popularized, he really mainstreamed this term as well. Together with due diligence. Some people talk about an empirical turn in smart mix scholarship, and that's really one of the most insightful literatures that you can read now, because you have all these due diligence laws like the deforestation regulation, right, with effects in the global south across the supply chains. But what happens on the ground? What are the ramifications? What are the dilemmas and the trade-offs when you have an economic power like the EU regulating transnationally and setting policies and deep changes around the world in developing countries? So a lot of contestation, a lot of nuances, and a lot of empirical research being done right now. And I think that is one of the most interesting things happening. And perhaps the last one, the fact that business and human rights is really becoming a multidisciplinary field. You have the top flying journal now, the Business and Human Rights Journal, that you might know well. It is a multidisciplinary journal. So if maybe 20, 30 years, business and human rights was a big, like the playground of lawyers, it was primarily human rights lawyers, international lawyers, doing human rights, and they decided to do business and human rights. This has changed. I mean, now it's so many different academic disciplines that are looking at this empirically, conceptually, systemically, that it's absolutely fascinating. And that's why maybe we call it a field, as in the question. So then I would say there is also a risk to this expansion in the environmental area. So we talk about sustainability due diligence. It's extremely important. There is a plus and a minus to it that I see. The minus is that, as you see with ESG standardization, the environmental side is much stronger than the social side, the human rights side. It's much more quantifiable. Climate change is an emergency. So there is a risk that most of the attention goes to the environmental side and much less to the social, the labor, the human rights side, which is seen as qualitative. It's difficult to communicate on. It's hard to manage. It's too subjective. It's difficult. Let's focus on the hard science, on the environment, pollution, and so on. So I think that's a risk that human rights will be downplayed in this whole discussion. The plus of it, I think, is that this whole discussion moves towards more a systemic treatment, a systemic solution to the problem of corporate abuses. And that's primarily because, for example, the due diligence directive came out of the sustainable finance work of the Commission. It came out of the Green Deal. So it very much came from the financial and the environmental side of sustainability. It didn't come from the human rights side at all. So that is important, because if the transition is green but also just, so it's based on human rights, I think that's a huge chance for human rights to be part of a systemic transformation of the economy. And human rights can end up stronger because of being at the heart of one of the most important transformations in our economies for generations to come.
Thank you so much, Radu. Indeed, there is also a huge discussion about EU environmental taxonomy, EU social taxonomy, and there are different intervention of scholars that social taxonomy is undermined. Yes, it's not getting so much popularity among different actors to abide by social taxonomy, which means to abide, to respect and protect human rights more within corporate activities. And also it's really interesting how it still correlates with different concepts. Yes, how it correlates with ECG, how it correlates with financial sector, as David mentioned. And actually, we received one question in the chat from Ruhia Isayeva. And the question is, could the investor's duty to exercise human rights due diligence in the context of responsible business conduct be potentially considered as a relevant factor in the assessment of fair and equitable treatment claims in investment arbitration? So it's also quite interesting how it touches upon different financial sector side of the question. Would someone of the speakers like to elaborate on? Maybe David?
Yeah, I can have a go. Yeah, so I can only read half the question for some reason, but it's the investor's duty to exercise human rights due diligence as a relevant factor in arbitration. I mean, it absolutely is. Yeah, it absolutely is. So I mean, it depends on the specifics of any arbitration treaty, bilateral investment treaty, or the rules of the arbitration. But I mean, it absolutely can be. Yeah, it absolutely is a relevant factor in demonstrating that they have met their obligations. Yeah, absolutely. And I mean, these kind of due diligence obligations are increasingly being written into bilateral investment treaties. Yeah. Is that an okay answer? I can only read half the question, but yeah.
Thank you so much, David. Yeah, speak about that. Yeah, and yeah, it's also as greatly previously underlined by David while we were discussing the development of the due diligence concept recently in the BHR field. We already touched upon the corporate sustainability. Yes, sustainable due diligence directive. We have a couple of more questions regarding different concepts and how it correlates with the due diligence concept. But before we move to that, I see Ruhia raised the hand. Can you please ask a question?
I'm sorry, I'm sick today. That's why I don't open my camera. But I just wanted to clarify about my question. I think it's, for me, it's very interesting to analyze and know the opinion of speakers. Because, you know, first of all, I don't know how much speakers and others participating know about this, but in the fair and equitable treatment claims in investment arbitration are very important. And in the assessment, the investor's conduct has emerged as one of such factors, which may justify the measure implemented against the investor by the respondent state. So, from the practice of the arbitral tribunal, it is evident that the investor's duty to exercise due diligence is considered by arbitral tribunals as an important factor in the evaluation of the fair and equitable treatment standard and state's liability, and in determining whether the expectations of an investor are legitimate and whether it entitles to the protection under the fair and equitable treatment standard. So that's why I was wondering wondering, but it is not clear from the legal literature and practice of the arbitral tribunals whether investors' conduct in investment arbitration also assumes the responsible business conduct, and whether the investor's duty to exercise human right due diligence can be considered as a relevant factor in the assessment of fair and equitable treatment claims. So that's why it was interesting for me to learn opinion of speakers, what they think. Can it be considered? So because we know that normal due diligence is considered, but what about human right due diligence? Can it be considered as a factor? Thank you. I just wanted to clarify my question.
Yeah, thank you so much for here. Yeah, would someone want to go with that clarification?
Yeah, I mean, I can just follow up. Absolutely, yeah. I mean, I think my answer is it absolutely would be. It's potentially relevant depending on the facts of the case, right? So I think it's only going to be relevant if there's a human rights relevant issue at the arbitration, right? But yeah, it potentially would be relevant, and also depending on the particular the bilateral investment treaty or whatever it is that's at issue. Yeah.
Yeah, thank you so much, David. And I just want to mention that we had our first webinar with this mentorship program, spring webinar series, and it focused specifically on investment treaties and human rights. And we will share with all registered participants to all the webinars the recording of all 5 webinars. So I hope it also will be very interesting, especially for here, for example, to listen to that recording also. Okay, we have still 15 minutes left, and we have 2 questions left, which are also interrelated between each other. So the first question sounds like, how does the concept of due diligence and impact assessment correlate with each other? And the second one is there any other notions that is arguably more suitable to be used to frame the process of identifying, preventing, mitigating, and accounting to factual and potential adverse human rights impacts of business actors? So basically, yes, we have, again, one more concept which is widely used in business and human rights field, impact assessment, which also is closely related to duty of care and to due diligence. Also, it's interesting to hear the opinion of speakers, how we can find maybe more suitable, or is there any more suitable concepts of due diligence, or due diligence is the best one in your opinion to cover, yes, this whole process of preventing, mitigating, and accounting the adverse human rights impacts of businesses. So maybe Maria, would you like to start with your...
So as for the question of correlation here between the due diligence and some similar notions, we can state that this notion is related to such similar terms here as, for example, good faith, best efforts, obligation, average behavior, or minimum standard of behavior, duty of best endeavors, or obligation not to do harm here, and as David mentioned, with risk management and reasonable care. And all of these notions are somehow connected with obligation to act reasonably and to respect rights of counterparty or business partner here, to refrain from committing some wrongful acts and from violating someone's rights. And although there's no uniform definition of this notion in legislation and in theoretical literature, the fact that it's widely used both by practitioners and by theorists means its importance, and we might even assume its irreplaceability. I dare to say that. And my suggestion is that there is no other notion yet more suitable to frame these processes, and because this concept was formed as a result of its long-term use for many years, and is now are widely used in practice. So replacing it can lead to some uncertainty and even to some confusion. So my suggestion is that we don't need to replace it. All we need just perhaps to outline its scope and maybe to define its types, which can be used in different spheres of legal practice. So it's my suggestion.
Okay, thank you so much, Maria. And Radu, would you like to intervene?
Yeah, sure. Yeah, I think what Maria said, it's very important, this idea of duty of care, and the breach is considered against the reasonable person standard. This happens in different bodies of law, especially in common law systems, and a lot of transnational litigation happens using the law of negligence or private law and invoking these breaches of the duty of care by parent companies when something happens in their global operation. So I think the duty of care is probably the closest related terms to due diligence. The question asked us also about impact assessments. I think that's very interesting because on one hand, the impact assessments are the know part in the know and show. So it's one of the first steps in due diligence for companies to identify their impacts, and then the rest of due diligence, it's about dealing with those impacts through prevention and corrective action. So in that sense, impact assessments is not a synonym, but it's a smaller part of due diligence. It's one of the 6 steps of due diligence and the responsibility to respect human rights. On the other hand, the impact assessments can be quite comprehensive. They can be human rights impact assessments or social impact assessments or environmental, social impact assessments. And the name of impact assessment says that it's only about identification and assessment, but when you read those hundreds of pages, you see that they end with special chapters on corrective actions. So those who write the impact assessments do not stop at identifying the problems, the risk, but they also suggest these are the recommendations, what you should be doing about that. So in that sense, it's almost the entire due diligence process in the impact assessment. So it's almost a synonym if you want to look at it in this way. Other terms, I don't think they're really too close related, but in human rights law is this idea of positive obligations of states. It's well established under human rights law that states have to act regarding third-party misconduct, as we discussed, the duty to protect. And under the European Convention of Human Rights, this is discussed as positive obligations. And they are quite expensive. They are kind of uncertain in content. It's a disputed and very fast evolving area of law regarding state obligations. So positive obligations to protect human rights, which requires to prevent, to investigate, to punish private human rights violators. It's a very important concept. The drawback is that this positive versus negative obligation, it's a shaky distinction. And John Ruggie considered it initially, and he wanted to frame due diligence as a positive obligation, the responsibility to respect human rights as a negative obligation, do no harm. So he got entangled so much with that it confused people a lot. So he dropped it all together because people understood positive obligations to be proactive action, while negative obligations was a reactive action, basically a duty to refrain from doing something bad. And due diligence is both negative and positive. It obviously covers the area that you should do no harm, you should refrain from violation, you should prevent harms from happening, so make sure you don't contribute to harm. But it asks much more. It's a proactive mindset that companies have to use to constantly look for risks and impacts and constantly improve their performance. It's a continuous improvement risk management approach. So in that sense, it is profoundly proactive and it's profoundly positive, especially when you see that the obligations cover the entire supply chain, so lots of third parties, which is a typical obligation to protect the positive obligations. But Ruggie didn't want his due diligence to be seen as very expanding, being negative and positive, demanding too much from businesses, because then the political consensus would have collapsed. So he was very keen to avoid this discussion, not to say that it's positive because that doesn't go good with states and businesses, but not to say that it's negative because then it guts the whole ambition of preventing and remedying human rights violations. So he basically avoided altogether this negative positive thing. Finally, the last one, maybe the core idea of liability. So human rights lawyers are very keen to deal with corporate unaccountability, with corporate abuses through the lenses of liability. And primarily strict liability, meaning liability that doesn't require to show the fault of the company. That is the most plaintiff-friendly version of liability. It makes it much easier to win a case against a company, including parent company, as David said. Otherwise, it's extremely hard to go after parent companies and show their culpability. So this idea of strict liability, it's a preferred option of some lawyers that want to create a UN treaty on business and human rights and to deal in a very decisive way with corporate abusers. And that solves everything in terms of due diligence. So if you have strict liability, you have that level of deterrence and punishment, then you can expect that companies will, of course, take the necessary measures to prevent human rights, not to be held liable. And that kind of preserves the black box. So you as a lawyer, you don't have to look what's happening in the company, the systems, the awareness, everything that due diligence requires. You just slap liability on it, and then everything follows, and you just apply the law. But this is politically and legally very problematic. So it's more of a theoretical ambition than a practical reality in the foreseeable future.
Yeah, thank you so much, Radu. There is a huge discussion also moving beyond, duty to respect human rights by businesses, which also touches upon how we understand the concept of duty, of responsibility, of obligation. There are a lot of connected theoretical intervention by different scholars within sustainability discourse, of course, because to reach sustainability, we need to do more in terms of achieving sustainable development goals. And also, it's really interesting to hear David's opinion on the maybe better concept that can be used, or is there any of them? Yeah, David.
Yeah, thank you. And I think I'm just gonna carry on straight where Radu left off there, really, because I mean, so I don't know if there's a more suitable process necessarily. I mean, I think we're kind of committed to due diligence at this point, and it would be not a good thing to throw it out and start again, because it's taken 14 years from Ruggie to get here, and longer than that if you include the process that it took him to get there. So yeah, it's not worth throwing out for sure. But there are definitely some issues with human rights due diligence. It is a bureaucratic kind of process. It is expensive. It is it does require a great deal of research to not necessarily produce a particularly guaranteed outcome. I got a quote here from a paper I was reading that the German human rights due diligence law, when that was implemented, Volkswagen had to install a new department with 70 employees just to cope with the administrative burden of that law. And speaking to, I'm in Australia now, and speaking to people in Australia. So there was a talk in Australia. So Australia has a Modern Slavery Act, quite minimalistic. And there's talk to improve that. One of the things that was suggested was human rights due diligence, or due diligence around modern slavery. So bringing the due diligence standard for corporations into the Modern Slavery Act. but very, very unpopular with corporations here, precisely because they're seeing they're having law firms and corporations having conversations with European firms, and they're saying, it's a bureaucratic administrative nightmare. Very, very complicated. We're not sure how to comply. These sorts of questions going around, which of course corporations are speaking in their own self-interest there. It is in their own self-interest to behave as though it's very complicated, but I think that doesn't mean it's completely untrue. And so this is where I was going to jump off what Radu was saying, because one of the things that I think is very disappointing change in the CSDDD is the removal of directors' duties and directors' liabilities here. So I think so. I've been teaching company law for a long time now, and I think there's a lot of options in company law, corporate law, to really change what businesses do, and directors' duties are really at the heart of that. If you make a director liable for something, a director personally liable for something, the corporation is going to be very, very careful about that. So if you say a director has a legal obligation to perform human rights due diligence to this particular standard, the corporation almost certainly will perform it to that standard, because directors are used to those kind of standards. They have to do it. That they will make it work, and that will also probably result in a form of human rights due diligence that does make sense and is more easily implemented. So I think those kind of standards that, as Radu was talking about, liability, that just place a particular obligation on a particular individual can be very, very powerful. Of course, they are controversial because it means the corporation does then have to do something, but they can be very, very powerful. And then the final thing I'll just say on this quickly is that, yeah, we're talking about human rights or due diligence, and we talked about duty of care, but increasingly I'm seeing lawyers come up with so many innovative solutions. So in Australia, disclosures are really, really powerful. So because they have quite a strong consumer law, they have quite a lot of rules around, they have a duty of honesty, right? So companies are frequently brought to court because they've said something that doesn't match up with their actions, have not matched up with their words. So they've advertised something about their environmental responsibility or whatever it is. That works really well in Australia because of the nature of the legal system here and the nature of the statute law that we have. In different countries can use different things, but I'm always impressed at how lawyers can use their own personal context to find solutions to these problems somehow, or at least to sort of move the bar slowly on these problems. So yeah, just to say to everyone watching that, yeah, like there are a lot of different options out there. Human rights due diligence is not the only one by a long shot, and most legal systems, it seems, do have potential options, and it's just a matter of a kind of critical mass working towards them, perhaps. Yeah.
Thank you so much, David. It was really interesting to hear about duty of honesty of companies operating in Australia. It's really indeed interesting to go to different contexts and see how companies operate in various environments. Thank you so much. I think we are closing to the end of our discussion. Does anyone has a question or remark or comment from the audience? Yeah, if not, we are really grateful to everyone who participated in our webinar, to Radu and David and Maria for preparing such a deep thoughts and such a deep contributions regarding due diligence concept, its developments and its characteristics, and we are really grateful for your time and effort for that. And we also still have 2 webinars to come next week. The next one will be on gender equality in Ukrainian companies and how it operates within crisis and, of course, within a war context. And the last one we will have on platform workers and human rights. So feel free to join us in the next webinars. And thank you so much again, and wish you a pleasant rest of the week.